All right, guys, we're going to go ahead and get started. We are welcoming everybody that's watching it online as well. So thank you for being here today. We are going to be talking about the top 5 legal things to know about social media. And we're so excited to have Maggie back. She's presented before. She is a wealth of knowledge on this topic. So we appreciate her time and Davis Brown for allowing her to come share her talents with us. A little bit about Maggie. She is an employment attorney with Davis Brown Law Firm, and she focuses on litigation, employment practices, liability insurance defense. She advises and defends employers, managers, HR professionals in court, mediation, arbitration, and administrative. Maggie primarily defends employers in disputes when it comes to labor. So today, she is going to help us through social media and what that means with your employees. So thanks, Maggie, for being here.
Thank you. I do always like when people clap for me when I start talking, so thank you guys for being so nice. So as Christina said, I work mostly in the areas of labor and employment at Davis Brown, and I do a lot of litigation and insurance defense work. So those are my primary areas of practice. And my contact information is up here. I'll also leave some business cards after I'm done if anyone wants to reach out to me later to discuss the law or just the weather or whatever. I love talking to people, so I usually include a little disclaimer with my presentations. I forgot to put it into this one, but we are talking about the law, so everything could change based on one different fact that we're talking about. So just remember that. So I'm always happy to take questions during the presentation, but if you do have more fact-intensive questions, specific questions, I'm always happy to answer those later. So we're going to be talking about social media in the workplace today. More than ever, social media has a very significant presence in the workplace. From use for work purposes, companies using social media for marketing, to employees becoming all too distracted by it at the workplace. There are obviously pros and cons to using it in the workplace, but the most important thing to start the discussion is to think about, as the employer, who, what, when, where, why, and how. Who's using the social media? What are they using it for? When are they using it? Where are they using it? Why and how are they using it? That'll help start the discussion in the workplace about implementation of policy, enforcement of policy, and just normal day-to-day practice using social media. So the third important thing to talk about is implementation of policy and follow-up and enforcement of those policies. To start off, we'll talk about our pros and cons list. And so it might not be easy to tell, but the pros are on the left, cons are on the right. But the pros of having social media in the workplace, it can aid in things like recruitment, market the employer brand. It can help deliver internal communications. And in that same vein, lower down on the list, I have communicate during a disaster. Some employers even use it for things like that. If there's a tornado, if there's an active shooter in the workplace, people have grown to start using social media to communicate messages like that to their workforce. It helps engage employees. It makes working in the workplace a little bit more fun if you've got a social media team, if you've got a marketing team who utilizes social media to advertise events, to brand the employment, or to brand the company. And for professional networking purposes, it's very useful. We all are aware of LinkedIn, we're all aware of Facebook, Instagram, and that is a growing market for professional networking. Some of the cons that we talk about, security. It can really have an impact on workplace security, and in the sense of confidential proprietary information that the employer intends to keep confidential. When social media blurs the line, you might not have a clear path as to how employees are supposed to or not supposed to release that information. It can be a conduit for harassment. It's very easy for employees to harass their co-employees via use of social media. Negative exposure. It then becomes very easy for employees to put their employer on blast on social media and say things. I was talking with a few folks in the back of the room about social media emboldening people. Things that you wouldn't necessarily say to someone's face, you might be emboldened to say online, and your employees are no different. Legal violations, we'll talk a lot about the National Labor Relations Act. Use of social media opens you up to a whole host of legal liability under the National Labor Relations Act. And potential loss of productivity, we talked about that. Your employees are just like any other human. They want to be on social media all the time. I'm guilty of that. I love Facebook. I love Instagram. I probably waste more time than anyone on any of those social media platforms. Yeah, don't tell anyone I just said that. Wage and hour issues also come into play. If you are assigning certain employees to work via social media to advertise the brand, to advertise events, how do you separate that time that they're working and not working? You don't know if they're working at home, you don't know if they're working at the office, so it kind of blurs those lines. So some things to pay attention to. The main problem we have with social media is employees saying things we don't like. We don't like to see them say certain things online about the employer. Employees, again, are just like your average person. They'll share their gripes, their struggles with anyone who will listen. And that includes anyone online who will listen. So then we have to think about these internal and external threats that poses to the company. Internally, how are employees using social media? Are they using it to harass one another? Are they using it to say bad things about co-employees? Are they using it to say bad things about a manager, about a CEO? So internally, how is this affecting the company? And then externally, what's the company and the employees, what are they both saying to the world? How is the company being branded to the world, and what's the reputation of the company look like via that social media use? Are we saying negative things to the public about leadership? Are we saying negative things that would affect the company's reputation in the business world? So how are we addressing these types of problems, and how do we address them appropriately? I've titled this section Firing for Online Behavior, but it should more appropriately be entitled How Do We Deal with This Type of Stuff? Firing is one option, but we'll also talk generally about discipline. I'd like to start off with a couple of examples. This first one I call the Nordstrom Example, and some of you may be familiar with this. It was all over social media and all over the news back when it did happen. In this case, we had a man, Aaron Hodges. He was a Nordstrom employee in Portland, Oregon. He was fired back in 2014 after he posted a social media post on his personal Facebook profile. And he was basically stating that white police officers should be killed. Aaron Hodges was a sales associate for Nordstrom, and he was seemingly addressing the protests that were going on back around that time. We all remember unarmed black men being killed with some regularity back at that time by police officers, and so there was a lot of controversy surrounding those issues at the time. And so it seemed like he was addressing those issues. His social media post stated, "Instead of slamming the police, I prefer a Kenny Ford approach. Every time an unarmed black man is killed, you kill a decorated white officer on his doorstep in front of his family." In a statement, a Nordstrom spokeswoman spoke out on this and said that the company does not tolerate violent conversation or threats of any kind. And she specifically stated, "What our former employee chose to post from his personal account does not in any way reflect our views as a company." Then on social media, Nordstrom also responded to some concerns that the public was having. You can see at the top, here was a fellow Twitter user who basically alerted Nordstrom to this social media post originally. Said, "Please see this Facebook post from one of your Portland, Oregon employees where he advocates killing police." Now Nordstrom made a response, you can see right below, says, "We apologize for the delay, but he is no longer one of our employees. We don't tolerate violence or threats of any kind." Now, it seems like Nordstrom's response was a pretty good one. It doesn't draw in politics to the issue at all. It doesn't put the employee really on blast at all. kind of deals with the issue in a seemingly appropriate way, but you can still see that right below that, we've got Ricky Thiel on Twitter who says, "What an employee does on his own time is not your business. Tomorrow I will return all the Christmas gifts I bought from Nordstrom." So what's an employer like Nordstrom to do in this type of circumstance? You think they did the right thing by terminating the guy for violent Facebook threats, but it appears you can't please everyone, because some folks are angry that this man wasn't allowed to voice his opinion on social media. So it's really demonstrative of the struggles that employers will face when this type of issue arises in these arenas. A couple other examples that I have demonstrating that this is becoming an increasing trend. Employers are firing employees or terminating contracts that they have with certain contractors for social media posts. We've got Roseanne Barr, famous example. ABC executives dropped her from her sitcom after a tweet she made about Valerie Jarrett, who served as a top aide to President Obama, as most of you probably know. And her tweet said, "Muslim Brotherhood and Planet of the Apes had a baby equals VJ." And VJ was later found to have referred to Valerie Jarrett. We've also got Kenneth Story. He's on the right. This might be a less known story, but he was a University of Tampa visiting assistant professor who lost his job after his tweet in 2017, where he said that Texas victims of Hurricane Harvey were experiencing instant karma for voting Republican. In other instances, we've seen people lose their jobs for social media posts made long before their employment even started. Another famous example is James Gunn. Some of you may know him as the Guardians of the Galaxy director. He was fired back in July of 2018 after comments he wrote on Twitter several years ago involving pedophilia and rape. And those resurfaced, and so his employment was terminated in that regard. So what do you do when your employee puts something like this on social media? Where does that leave you? That's really our million-dollar question. You don't want to expose the employer to liability by taking the wrong action, by taking too swift of action, but you also want to protect the employer's reputation, their brand, protect other employees from this type of behavior. So deciding how to respond is really, it's not an easy task. It's very difficult. But what we need to start thinking about is protecting the employer from liability by not making rash decisions on this front and going through a little bit of analysis when we're encountered with something like this. So the first thing to really think about, and we will talk about this in a little bit more detail, does the social media post that we're talking about involve protected, concerted activity? And the second thing to think about is whether it does or it doesn't. We need to think about balancing the damage or potential damage to the employer's reputation versus fostering a workplace that's supportive of people's individual endeavors and that doesn't micromanage people's social media posts because just fired you. Good luck with your no money, no job life. So what is really more damaging to the company's reputation? That future employees tweet that maybe reached a few people, or the company's response that could have reached potentially a lot more people and is seemingly pretty immature and childish? In my opinion, it's the second one that's more damaging to the company's reputation. So I know the temptation can be real to kind of clap back at things like that, but to the extent you can resist doing so, that's definitely the recommendation. Another thing to think about in the calculus when you're talking about specifically terminating someone for online behavior is, will the employee be able to collect unemployment benefits? As most of us may know, an employee will be denied unemployment benefits when they're terminated for misconduct. We have a case coming out of the state of Washington where a young woman named Sarah Black was employed by Puget Sound as one of their security officers. And in February of 2012, while at home and she was off duty, she posted this message up here on Facebook talking about police officers getting shot and karma and a variety of other things. She applied for unemployment benefits, and ultimately, a Washington appellate court held that she was entitled to unemployment benefits after the employer had terminated her. The court found that the employer had not established that the termination was for misconduct related to her work. So although we might think of this as misconduct in its true sense, this wasn't misconduct under the unemployment benefits statutes such that she could be denied benefits. So the court there found that if you're going to term someone for misconduct and expect that they don't receive unemployment benefits, that misconduct has to have some nexus with their work, has to result in some harm to an employer's interest, and be violative of some code of behavior or some contract that the employee and the employer had together. So it's not just as simple as, well, look what she said online, gosh. So what's the lesson here? There might not be a completely clear path for the attorney, or excuse me, for the employer. And the employer may still have to pay for these types of things. Even though you think you're doing the right thing by terminating this person who's acted this way online, you might still end up paying $1,000, $2,000 for their unemployment benefits. Yes, sure.
Is there a difference for the employer if the employee posts something on social media while they're at work versus away from work, quote, off duty, and so on? Is that a factor that comes into play for the employer as to how to respond to this and the gravity of it and so on? Can you speak to that at all? Is that an issue at all that ever comes up?
Sure.
And consideration, I guess.
Just to repeat the question for those tuning in online, the question was, is there a difference between whether someone's posting off-duty or on-duty? And does that factor into the calculus as to whether you consider discipline or termination, et cetera? And it does to a certain extent, I will say. You can see in a lot of these cases I've mentioned that the posts have been off-duty. The problem there is the employee hasn't taken particular measures, and what I didn't reveal is likely in these scenarios, employers have had policies in place that say, if you're going to post something online, especially of an inflammatory political nature, you need to make it clear that this is not the view of your employer. This is your personal view. So that's where it kind of blurs the line between whether you're on duty, off duty. It might not necessarily matter. The on-duty versus off-duty calculus might come into play when you're talking about productivity, loss of time. If someone's screwing around online when they're supposed to be working, that could be a whole different subset of issues. Does that answer your question? Okay, great.
I don't want to, you may be getting to this later, so
no problem.
You kind of said something about like relationships that you have with an employer, like an employer putting specifically something in a contract, or if you have some kind of relationship, business relationship. And then the second thing is like, specifically like it's a public figure, somebody, for example, that's going to be in the media a lot representing a company, and then they're obviously then saying something on their own Twitter feed or Facebook page. Is it common that people are making contracts now to limit people's speech in that way?
And so I should be clear, the context in which I brought up employee contracts is mostly in the unemployment benefits context, that if someone's violating a policy, that might imply misconduct, or violating a term of a contract, that might imply misconduct for unemployment purposes. What I don't want to see is people inserting language in contracts. That should be reserved for your policies, and when I say language, I'm referring to language, discussing social media guidelines. I wouldn't want to see those come into an employment contract. What an employment contract should do is reference the employee handbook and kind of reincorporate that, but we are seeing a lot of policies, and I hate to call them speech limiting policies, but more of guidelines for how people, especially people who are in the public and might be speaking on behalf of the company, should be conducting themselves when they are speaking actually on behalf of the company. What you don't want to do is limit people's personal speech. And that's where the fine line comes into play. And we'll talk a little bit more about policy language that can affect that. But that's where you want to be really careful when you have someone who's going to be in the public eye and speaking to the media and so forth.
In this instance, would it make a difference whether or not at that organization, like linked to it on her profile versus not?
That probably would have made a huge difference to the court here if she said, I work for Puget Sound and you know what they think about this issue.
Or, even how you can say, I work at someone partnership, and it links it, and so, when
and
it shows she works there versus
anything that, and I'm doing a terrible job of this repeating for those online, but to repeat the question was, would it make a difference if this woman on the slide had linked her employer to the social media post in some way? And yes, that would make a huge difference, because anything that implicates that these are the views of the employer would give the employer more reason to discipline her, terminate her, etc.
Even if she had said, this is my personal opinion, it makes no mention of where she's at, that makes a difference.
And the question was, if she had qualified her social media post, would it have made a difference in that if she had said, these are my personal opinions? That might have made a difference in this particular circumstance. Well, it probably actually wouldn't have made a difference to the outcome of the case. She still would have gotten unemployment benefits, but it changes the analysis a little bit. It makes it a little bit more clear in that regard, in fact. So we'll talk a little bit about Section 7, and that should say of the NLRA. Apologize for my typo. This provision comes into the conversation 9 times out of 10 when we are talking about social media in the workplace. Because the National Labor Relations Act is where we look to determine whether something is protected, concerted activity. And that's the main calculus we're looking at. All workplaces are covered by the NLRA in some capacity. And again, sorry for my typo. Section 7 of that particular act is the one you'll hear of the most, and that protects concerted activity, the employee's right to organize a union or protest employee treatment. And again, this applies regardless of whether the company has a union in place. It applies almost entirely across the board to all workplaces. Then we look at Section 8 of that same act, which prevents an employer from interfering with an employee exercising those types of rights. Now, we have to look a little bit at the political climate that we're in right now to determine how we view this issue at the current time. Just recently, the NLRB, the National Labor Relations Board, has taken a different position on how we look at whether something is protected concerted activity and whether an employer rule violates that. Under President Obama, we had a different view, a different NLRB than we do now under President Trump. And those two boards have taken different views on different things, and so the rules have continued to change. And if we see a shift in presidential regimes, we will see a shift in the NLRB likely. So it's important to pay attention constantly to what the National Labor Relations Board is saying on these issues because it will help immensely in your workplace. The old rule, which we tend to think of as more employee-friendly, was that if a worker could reasonably construe an employer rule to interfere with their rights to engage in protected activity, then that would be violative of the NLRA. Now, the new rule, which we see being implemented now by the NLRB, is slightly more employer-friendly. After a case that came down in 2017, the board shifted its standard. And so now the board evaluates employer rules by balancing kind of the nature and extent of the rule's impact on protected rights with the employer's potentially legitimate justification for having that rule in place. That sounds like a lot of mumbo jumbo, but it's basically a technical way of saying that we're looking for more reasons to validate employer rules under this current NLRB. The board will look at rules based on 3 categories, going from presumptively lawful to presumptively unlawful. And as we go down the scale, from category 1 to category 3, we're looking at potentially more chilling effect on protected activity. So for example, a category 1 rule that would be presumptively lawful might sound like this. Employees may not comment or speak on behalf of the company without prior written approval. Or employees may not make disparaging remarks about other employees. Now, in contrast with a category 2 or 3 rule, which might sound like blanket rules prohibiting employees from making disparaging or negative remarks about the company, or blanket rules prohibiting employees from making false statements or inaccurate statements, or telling employees that wages are confidential, or preventing them from talking about it, we can see that stark contrast between the category 1 and category 2 or 3 rules. So there still is significant protection for the employees built in. But let's take a step back and look more broadly at Section 7 of the NLRA. Historically, under the NLRA, you can't prohibit discussions by your employees about salary, wages, benefits, hours, discipline. You can't prohibit talk like my boss is a jerk, my employer is awful. You can't prohibit direct agency reporting if someone wants to report something to the EEOC or the Iowa Civil Rights Commission, the Department of Labor, OSHA. Rules that prohibit that type of reporting have typically been found unlawful. But the key here is the word discussions. So where workers are engaged in a dialogue, that's where we're really, those discussions are protected. That's where those words are protected. In a dialogue with each other, where they're criticizing working conditions, pay rates, management, that's all considered concerted protected activity. However, and this is where it's difficult to tell sometimes, but individual gripes on social media in the workplace are not necessarily protected as protected concerted activity. If there's not an active dialogue going on or solicitation of an active dialogue, you might not have protected activity. But that's hard to tell, isn't it? I mean, almost anything that anyone says on social media could elicit response from coworkers. So it's difficult to draw that fine line. And some of the NLRB guidance will tell you that even when an employee is talking to other employees and they're attacking the employer on terms unrelated to employment terms, an offensive remark about, say, a CEO's appearance, for example, that can be a legal basis for termination. It might not be protected. But we can't necessarily know that up front, that stray comment wouldn't elicit more discussion about a term related to employment. So it can become sort of difficult and it can be hard to tell. And aside from social media posts and comments in the workplace, actual conduct can be protected concerted activity. For instance, the employees have the Section 7 right to protest employee treatment, to gather, to protest. So the physical act of protesting can be protected activity. The NLRB doesn't like prohibitions on, when we use these broad words, prohibitions on disrespectful behavior, negative behavior, inappropriate behavior. The NLRB doesn't like that. False statements, unless they're maliciously made. The NLRB doesn't like prohibitions on that. So we have to be careful on prohibitions of this type of behavior, because what does all of this feel like? It feels like insubordination. That's that kind of term of art that we use in the employment context. This all feels like the employee is being insubordinate if they're saying all of this stuff. But if you deal with it in the wrong way, or if your policies have this broad, overarching language, you can get in trouble for that. can get in trouble for disciplining the employee. You can get in trouble for terming the employee. So we have to be really, really careful. So how can we build policies that will help us without hurting us? We'll talk a little bit about some policy language that can be harmful, some policy language that can be helpful. So instead of focusing on some of the negative words that I mentioned on the previous slide, like disrespectful, things like that, focus on professional, courteous, civil. Those are the terms we want to use in defining our workplace and talking to our employees about how we want to act in the workplace. And when you're using these terms, you want to be specific with regard to this is how treatment should occur between employees and members of the public, between employees and customers, employees and clients. You never want to refer to the interaction between the employee and the company, because that's where the protected concerted activity comes in. That employee has every right to say something negative about the company, to complain about the company. That's the speech we don't want to limit. Harassment is a big one that is kind of the exception. So if we find employees who are harassing other employees, harassing customers, clients, other members of the public, that's not going to be protected concerted activity. So you don't have to allow that type of conduct.
Has the board made any rulings in that area?
That's one of the more clear delineations by the board, where the board says, I can't pull any specific examples right now, but the board oftentimes finds that as clear exception to any protected concerted activity being found. And I mentioned this term insubordination. That's a term that I like employers to avoid, if possible, in their policies, because it can be a bit overbroad. And again, it's a term of art that we really use. Not to say that the spirit of that word can't be kind of woven into our policies, but that specific word should be avoided. A rule that requires employees to be respectful and professional to coworkers, clients, or competitors, but not the employer or management, will generally be found lawful. So if you exclude employer or management and you exclude that word insubordination, your policies are likely going to be okay. But it's important, very important, to think about the language we use. Yes?
To this, because if you go back to that prior slide, this is what I've seen. I'm a consultant. I work with employers on language and so on. One of the issues that comes up is I want to make sure that my staff knows that I don't tolerate disrespectful behavior, inappropriate behavior that might be rude, that creates tension among people, so forth and so on. Okay? If that happens, you'll be coached, and if it continues, you can be disciplined up to including discharge. So I'm reading this, and I'm saying, you can't do that. But yet, they're an employee at will.
Sure.
All right, which means I can terminate you for cause or no cause, as long as it's not for illegal reasons. So I see a conflict here.
Yes.
Can you, maybe I'm way off target here, but
no,
I'm an employer and I'm reading this, I'm thinking, oh geez, all right, so what, I can't deal with the issue of disrespect in the workplace with each other?
And that's
couch it in a different way? Can you speak to that?
Sure, that is a great question. The question was, to repeat it for those of you online, was whether the at-will employee nature of the state of Iowa is an at-will state, whether that affects the calculus here, what we're talking about here, in terms of trying to encourage a respectful, professional, courteous workplace, and how do we deal with that. So the issue really breaks down to, you just actually made my point for me, I think, in what you said. You can term anyone for any reason whatsoever if they're at will, unless it's illegal. The NLRA is our law. Not only do we have to abide by Title VII, by the Iowa Civil Rights Act, we also have to abide by the NLRA. So we can't chill employee speech as it relates to complaints about the workplace. If someone is being uncivil online, if someone's being disrespectful to their coworkers, if someone's harassing, those are all exceptions to that type of speech. But if they're saying, hey, I don't get paid enough for this, and insert expletive, job that I do, that's the type of speech that, though it seems disrespectful to the company's got to set feelings aside and sort of separate that. Does that make sense? It is.
Good job of distinguishing.
It is very fine, and you make a good point in noting that because it's difficult. It's not easy to make that distinction.
Thank you very much.
Yes. So we're going to run through some language examples that have been found in past employee policies that have been found either to be presumptively lawful or presumptively unlawful. So we'll start off with one of the bad examples. Be respectful to the company, other employees, customers, partners, and competitors. Now, it's that red and underlined language that is the language that consistently gets us in trouble. I know, and it seems counterintuitive because we care about the company, we care about our brand, we care about the reputation that we present. But recall back to the NLRA. You can't chill that employee's speech in complaints about the company. And when you're talking about being respectful to the company, that is such broad, overarching language that it could be construed by an employee to chill that type of talk. Any complaints about wages, benefits, salary. Now, some better language that we see. Employees will not be discourteous or disrespectful to a customer or any member of the public while in the course or scope of company business. No use of racial slurs, comments, or insults. Any logos or graphics worn by employees must not reflect any form of violent, discriminatory, abusive, offensive, demeaning, or otherwise unprofessional message. So these policies that we see really promoting civility, that's where we can kind of take solace in that we're not totally prevented from telling employees, hey, you gotta act cool at work. We have that ability to couch it in this way, but it's got to be couched in that way. Otherwise, you're going to find yourself in trouble. Some other bad language. We're talking about being cooperative, being civil. So that language is more times than not, found to be okay language. Now, an employee's Section 7 right also includes the right to criticize the employer or the employer's policies in a public forum. So not just between employees, not just between employees online, but in a public forum. Speech right there. So some other overbroad examples, and this one always bugs me. Do not send unwanted, offensive, or inappropriate emails. So what do you do about this? You've got to craft some policy that prevents folks from harassing each other over email, because we've all seen that classic example of the boss forwarding some sexually explicit joke to his buddies and then he accidentally copies in his assistant, something like that. And we're talking about instant harassment suit. So what do? This is a seemingly harmless policy, but actually the NLRB would find this to be presumptively unlawful. So you may want to, instead of a policy like this, be a little bit more specific with what you're talking about. You may want to define the emails as harassing or discriminatory, something like that, using those specific words that are, like NLRB buzzwords. They love those words. Using those instead of these overbroad, because these overbroad words could imply something different. And the right to criticize the employer in public forums also includes the right to communicate with news media, government agencies, and third parties. So again, some bad language that we've seen in policies. Associates are not authorized to answer questions from the news media. Well, that goes directly, or seemingly directly, to the employee's own personal thoughts. It doesn't limit the employee to talking about their own personal thoughts, but it encompasses speaking on behalf of the company. It encompasses speaking on the employee's own behalf. So it's overbroad. Some other bad language. If you are contacted by any government agency, you should contact the law department immediately for assistance. Seems harmless, right? But again, this might chill required reporting to agencies or participation in agency investigations. If you've been called by the EEOC to participate in a harassment investigation, what are you supposed to do? Tell the person who's been harassing this other employee first before you report to them? No, so a policy like that would certainly chill speech. It would be better to include policy language like this. The company strives to anticipate and manage crisis situations in order to reduce disruption to our employees and to maintain our reputation as a high-quality company. To best serve these objectives, the company will respond to the news media in a timely and professional manner only through the designated spokespersons. So that is indicating to the employees that they may not speak on behalf of the company as opposed to speaking on their own behalf. So some takeaways from this particular section: make sure you're looking at the construction of your policies, the context in which you use certain language. That can be really important. The difference, while two certain policies may mean the same thing, the words selected by the employer can make all the difference. And avoid those easy and obvious traps, those broad words, the clauses that tell employees that they can't say anything negative about the company. Those are like the low-hanging fruit that the NLRB is just gonna pluck down. And consider some savings language. We haven't talked about this really yet, but savings language might be something to the effect in your policy that explicitly saying, nothing in this policy shall be construed as limiting your rights under the National Labor Relations Act. Now that seems obvious, but putting that language in your policy is really valuable. The NLRA NLRB actually likes to see that specific language referencing the actual act, the actual law. And they've found policies that include that savings language to be presumptively lawful when otherwise some of the words in the policy might indicate it's presumptively unlawful. And then including examples in your policies is never a bad idea, but always couching it with the language including but not limited to give yourself some kind of wiggle room. It's always a good idea. And then using common sense in enforcement. When you're enforcing your policies, make sure you're doing it even-handedly. Make sure you're actually following the policy. It's when employers just try to stray from the policy that they get in trouble, that they get accused of discrimination, that a whole host of other things happen. Ultimately, with regard to your social media policies in general, your framework should have 5 principles in mind, depending on your business and your company needs. These are kind of my 5 guideposts to your social media policies and things that you should think about addressing. Keeping confidential information confidential. Now this can be a struggle for employers and can raise concerns under the NLRA because it depends on how we define confidential. What we have to be concerned about is whether we're talking about protected company information, if we're limiting it to that, or if we're going to address whether disciplinary action will be taken for breaking the law. Do not post pictures of other information about your participation in illegal activities or imply that you engage in such conduct. For instance, if an employee is posting pictures of themselves shooting up heroin outside of work, yeah, you can fire them for that. Yes?
About the second one about
Oh, sure, let me go back.
And about your first bullet under that. So the scenario, 2 coworkers, let's get into the harassment situation.
Sure.
And so there's harassing pictures, could be sexual pictures, one's exchanging, the other one doesn't like it, it's happening on, and they may post stuff on social media. What discretion does the employer have to manage that, to get involved in that? It's not happening, quote, at work, it's happening away from work.
But it's happening between coworkers?
Two coworkers, is it what latitude does the employer have in dealing with that?
Sure. So the question was if, let's say, two co-employees are exchanging, or one employee is exchanging explicit pictures with another employee, and how do we deal with that situation if maybe it's happening outside of the work context? What discretion as employers do we have to deal with that? And I would say you have a lot of discretion. You have a lot of power in that circumstance because you have to protect your workforce. This is tantamount to what happens at a company holiday party, for instance. If you see inappropriate touching between a coworker and another coworker at a holiday party, it's outside of work hours, but that's still company activity. We're talking about still company time, still company action. When it's happening outside the workplace on social media is where the lines get blurred a little bit. How do we decide if that's work time or not work time? But I would say if you've got a co-employee who's coming to you as management and complaining about that especially, you've got to take action. Even if that's not happening, might be worth some investigation, especially given the co-employee relationship there. So. If it's consensual activity, you might have nothing to worry about there, but it's still worth investigating for liability purposes.
Thank you.
So some other things that your social media policy should focus on are protecting privacy rights of yourself and others, and when I say yourself, that's the employee. Being cautious about how the employee shares personal information on social media. Not posting pictures of or personal details about their coworkers. If you're in the health industry, patients without express permission. Staying mindful of privacy laws, and the big one that comes to mind is HIPAA, but that's health related. So if you're in the health industry, pay attention to HIPAA, but pay attention to other privacy laws. There are common law privacy laws as well that implicate everyone. And cautioning employees not to destroy personal media without approval if it's been used to transmit company information. That could become relevant in a lawsuit if you have to place a litigation hold on all relevant information. Could become relevant for a variety of other reasons. And then remind your employees in the policy that standards of conduct still apply via social media. Any conduct that would be grounds for dismissal at work is grounds for dismissal if done online. So that still takes into account this NLRA that's looming over us and telling us not to limit employee speech in certain ways. Still consistent with that, but may need to be said in your policy. And then what belongs in medical records goes in medical records. Again, if you run like a long-term care facility, your employees, your nurses shouldn't be posting anything online, et cetera. So once you have your separate social media policy drafted, and I do suggest a separate social media policy, even though we're talking about consistent standards of conduct across the board, it's not necessarily enough to rely on those standards of conduct as woven through the rest of your policies. You should have a separate social media policy set forth for your employees. And what you should do is have them sign a separate acknowledgement that they've received and acknowledged that receipt of that policy. The NLRB always looks to see whether employers have that separate policy and whether the employee has received and acknowledged that policy. That's like step number one in their investigation of any of these certain issues. So the last topic I want to touch on, as long as I have time, is social media and recruitment. Social media can be the biggest double-edged sword in recruitment that you can think of. First of all, can an employer legally examine a candidate's social media presence as part of the recruitment process? Well, generally, yes, but there are other concerns to be addressed, and you have to be careful about how you do it. In this vein, you might want to also have a policy that talks to your employees, especially those on your recruitment team, your hiring team, about how social media is to be used in the recruitment process. What should folks be looking at? What should they not be looking at? What types of considerations are inappropriate and what are appropriate considerations? Social media has the danger of drawing up things like false identity. People can associate anyone's picture with a social media profile these days. So when you're looking at someone who's applying for a job at your company, be sure that you're looking at the actual person. If you're not sure, don't look at it. It also might dredge up inaccurate information. For instance, someone's Facebook wall might contain posts from some of their friends that contain inflammatory political information. Maybe some other, charged issues that friends decide to post on social media on their friends' walls. And that might not reflect the views of the person that you're actually trying to research on social media. So be careful about what information you're drawing up. It might also dredge up impermissible subject matter. You might learn something about a protected class that someone falls into, and even though you might not think that that affects your decision, your calculus, when determining whether to hire this person, it might not, but it also might bias you in some way. It also might give the appearance to someone who's challenging a hiring decision later on that you've made an impermissible consideration, even if you haven't. Additionally, don't necessarily pass on someone who has no social media presence. Sometimes in today's world, we're like, whoa, he's not on Facebook. He might be a weirdo. But this also can have age discrimination implications because disproportionately, older Americans are not as engaged in social media as younger Americans, just statistically. So this can have discriminatory implications. I put this quote up here because I think it's particularly appropriate. This is from an HR expertise panel member from SHRM, the Society of Human Resources Management. Social media has opened the door for us to know people's intimate views on things that are not work-related. So it's opened the door for us to look at things that we should not be looking at. This became particularly relevant in this Gaskell case. This came out of the state of Kentucky. Mr. Gaskell sued the University of Kentucky when he was rejected for employment as a scientist in one of their departments after another employee who was actually on the hiring committee dredged up this lecture that Mr. Gaskell had previously given that gave rise to some of his religious views. And she circulated that lecture via email to the rest of the hiring committee. The hiring committee ended up thinking that because he had these conflicting religious and scientific beliefs, that maybe he couldn't do his job appropriately as a scientist with the university if hired. The court ended up denying the university's motion for summary judgment, where the university asked for the court to dispense with the claims, the discrimination claims. The court denied that motion and said that there were issues of fact as to whether his religious beliefs were an issue, a motivating factor in the university's decision not to hire him. And so these emails that were floating around where the hiring committee had discussed his religious beliefs came into play. Again, you think people put a lot of stupid things in email, so think about that when you're circulating things at work.
Maggie, we have one question from one of our viewers online.
Sure.
Nathan would like to know, in regards to social media and recruitment, does a potential employer need to obtain permission from the applicant prior to looking at their social media?
So the answer to that question is no. It's never a bad idea to obtain that permission. It only will solidify your actions in looking at that social media and might protect you from some privacy law issues. But no, the answer is no, especially no in Iowa. You do not need to get explicit permission from the employee before looking at social media. Looking at social media might also have implications for the Fair Credit Reporting Act. This act is the primary federal law governing employment background checks. And this is a very complex law, can be violated in like a million different ways. So it's one of the big traps of doing background checks. It's far too complex for us to go into the details of it today, but it's possible that using social media, if done in the wrong way, could violate that act. So you just have to be really careful. The last issue I really want to address is with regard to passwords and forced access. This refers to the ability of the employer to access usernames and passwords for personal social media accounts of employees and applicants. Since about 2012, there have been several states who have begun enacting legislation to prevent employers from requesting this specific information. And about 26 states now, so about half the country, have enacted such legislation. Do you think Iowa is one of them? We are not. So Iowa does not prevent forced access to usernames, passwords of social media accounts of employees, of applicants, which is kind of scary when you think about it. However, even though the law says it's okay, I would strongly encourage folks not to do that. It has a variety of other implications. Again, those social media cautionary tales that we've already talked about, they're like extra amplified if you ask for someone's passwords, someone's usernames, to specifically get into their accounts and look at the information there. You might be talking about privacy concerns, you're talking about NLRA concerns, you're talking about a whole host of things. You're opening up like Pandora's box, so just caution not to do that. And finally, with employees, we're inevitably going to experience issues in our time as employers with settlement agreements, lawsuits, things like that. And there's a good reason why in some of these settlement agreements, we, as the employers, require confidentiality. Because afterward, after a settlement has occurred, after a lawsuit has occurred, we might be worried about employees posting bad things on social media. And this was one of those cases. This was Patrick Snee versus Gulliver Schools and School Management Systems. Patrick Snee was a former headmaster who was terminated, and after he went through the litigation process, ultimately ended up settling out with Gulliver. And after he did, he posted on his daughter's Facebook page, "Mama and Papa Snee won the case against Gulliver. Gulliver is now officially paying for my vacation to Europe this summer. Suck it." This was Patrick Snee's big $80,000 mistake, because his settlement agreement had a provision in it requiring confidentiality and liquidated damages if he violated that. And when he did, he was subject to this $80,000 penalty. So, good reason for employers, again, if possible, to include those confidentiality provisions in non-disclosure agreements, settlement agreements, etc. That is the last item I had to address with you guys today. Thank you so much for having me. Again, here's my contact information. Always happy to talk with anyone who wants to chat.
Right. Yep, thanks. We're going to wrap it up real quick.